Mr. Feinstein, it's your client's application. I didn't know if you or Mr. Ard was going to argue for
one housekeeping matter. I prepared a revised order on my application based on the hearing that we had last time, and then I circulated it, and the state did not approve it for entry, and asked that we appear today for the purposes of them asking for a clarification on what the court ruled. I uploaded it so that at least it was before the court, so you could at least see what the proposed order that I circulated looked like. The U.S. trustee had one administrative change to it that I have no objection, is that we said we would provide to the United States trustee the names, contributions, the date of payment, the amount of payment, and they would like just to say to provide a list of the names of the contributors, the dates of payments, and the supporting documents. We provided to the U.S. trustee the actual checks, contributions that had the contributor's name, address. It's a check, the date, the amount, signed by the donor, and we provided all the checks. The U.S. trustee would like us to take those checks and just make a list, which is easier for them to review, and then just attach the checks to the back. I said, that's not a problem. I take my...
So that's a slight revision to what you put in this recently filed.
So that's okay. So where we are on my proposed order that I submitted to the court is based on what I understood the court to say under the 327 disinterested test. The court was concerned that the U.S. trustee should see or at least have information as to the donors that provided funds to the Eyman Legal Defense Fund that constituted the retainers that were paid to me and to the other three attorneys. So we compiled, again, copies of all the documents that constituted the funds that were in the accounts that were distributed to the four attorneys that made up their retainers, so that the U.S. trustee would have an opportunity to review that under their 327 analysis, that there wasn't a conflict or there would be disinterested. The state wanted that changed, and what they wanted is they wanted a list of all donors to the Eyman Defense Fund for the last 2 years. From any source, used for any purposes, and I said I thought that was outside the scope of what the court ordered on a 327 analysis for disinterestedness, and I said we've gone back and we've provided, I think it went all the way back to about June, so about 7 months worth of contributions, and they wanted to change that to January of 2017, which there were no funds from those last 2 years that went into our retainer. So I think that's outside the scope of my application to be employed or the disinterested test of my application. Maybe it's something that can be provided. Maybe the U.S. trustee will ask for it in the ordinary course. Maybe it's a required document in the administration of a case for providing financial information that the debtor is required to do, or maybe it's a 2004 kind of request. But as to my application and my request to be employed and my disinterestedness, I understand that narrow focus, the court said, provide the U.S. trustee with the backup documents as to what money you have in your trust account and who gave it to you to put it in that trust account, which we've done, and that's what the order says, the proposed order that I uploaded says. So the state has their own thoughts on that, and they said they'd like to show up today and get a clarification before they would sign up on the order. So that's where we are on my application.
All right. Well, I mean, it's it's really not on for either presentment or hearing, but I mean, since you're here and arguing about it, let me at least ask a couple of things.
Yeah.
We're getting way down into the weeds beyond what was discussed at the prior hearing, but I think I did say, well, I think what had happened is you had indicated that you had provided a list to the UST.
We provided all
I didn't
the bank
read-
statement information.
Right. It certainly was not emphasized to me by any party that
Yeah.
you have an ongoing fund, and that may not represent all the donors to that ongoing fund, and then we have a commingled fund from which these retainers were paid. So my concern was in bankruptcy, under the disinterestedness aspect, a requirement for
Yeah.
appointment, that I know where the funds came from that then paid the retainers.
Yes. That's the way I understood
Certainly
it. So,
under a normal analysis of a fund in bankruptcy, or, most legal settings, if you went down to a zero balance at some point, I wouldn't care what was in there before the zero balance, assuming that zero balance was hit before the bankruptcy, or before these retainers were paid. But if there's a factual dispute about whether the list you gave is really the list of all the donors whose money in a pooled sense was then used to pay these retainers, I would be expecting that list to be provided to the UST. And frankly, I was allowing that as kind of a accommodation, if you will, to these donors who probably never expected when they put money into this fund that their name was going to show up in the bankruptcy docket of Mr. Eyman. They had, I assume, no contemplation of that when they donated their money.
Okay.
So as sort of a privacy protection, not saying that those names couldn't be put on the record, but I was allowing the list to merely be provided to the UST, although I assumed that the UST would then be under no restriction to provide that list to the state or whoever else wanted to access that record. But so as you've just raised it, though, do I have a dispute of material fact as to whether the list you gave the UST contains the names of all of the donors that funds could have potentially been used to pay these retainers?
Well, we provided the bank statements, and then what we've done is supplemented the deposits for the bank statements to actually go back and provide all of the donors that made up the pool of funds that went into the bank account, so that the U.S. trustee could then review the donor list under a 327 analysis, basically to see if there's any conflict of interest.
So that was all the donors ever?
That's all done. So it's not all funds that were ever paid ever into that fund, because it makes up the body of funds that were in the account at the time that the disbursements to the various
But I mean, is that because it hit a zero balance, or how are you figuring that out?
There's no balance left in the account.
No, but before the retainers were paid, had it hit a zero balance?
No.
Well,
if I can address the point at some point, but go ahead.
All right, so
we went all the way backwards to all deposits that would then...
Well, but that would be assuming that you're accounting this LIFO, right? Last in, first out. Because if there were funds in the fund right along, I mean, for most purposes, I think we assume FIFO accounting, not LIFO. And so as long as funds were in that account, I have no way of saying the donors that provided the funds for these retainers didn't include somebody from ages ago if it never hit a zero balance.
Okay. I don't know how they were...
Well, I'll hear from the state for a minute, but it's actually not on for hearing. So I make these comments just to tell you where I'm coming from. I would expect the full list of whoever contributed into the fund that could have possibly been used for payment, regardless of how you account for it or under the various ways you could account for it. that would have paid these retainers. I'm only requiring that at this point to be given to the U.S. trustee.
Yeah, okay.
All right. You may, Mr. Smith. Go ahead. And I do appreciate the fact that you're here doing your duty, working for free at the moment.
Thank you, Your Honor. I'm a little bit of a wild card here because I haven't filed anything and I haven't had some of the discussions with counsel that I might have otherwise had if I weren't furloughed. But,
well, since this really isn't a hearing anyway, I'll hear from you.
Okay. I did listen to the recording of the last hearing, so I am aware of the dialogue that occurred there. And I do want to correct what I believe is an error in the record, in that at the time Mr. Feinstein represented to the court that he had provided all of the information about the donors to my office. That wasn't accurate. We've received since post-hearing and after the court's comments, we've received the information that Mr. Feinstein indicated, bank statements, copies of checks. I've seen it come across. It hasn't been reviewed by anybody. We don't have staff necessarily to review it at this point in time. And that raises the concern about siloing that information. Unless
you have no way of then disseminating it once you receive it and
analyze it. And I believe the court and other parties have a right to analyze disinterestedness and conflicts of interest as well. And if that information is only being provided to my office at a time when it's not being as rigorously reviewed as otherwise, it leaves a void that I don't think is necessary. If there are privacy concerns that counsel wants to raise about it, that's fine, but it seems to me that otherwise it should just be part of a supplemental declaration for appointment of counsel, and it should be part of the monthly operating report. So those were the comments I wanted to.
All right. Ms. Dalton or anybody else for the state to make any comment?
The state's concern with the language that was proposed by Mr. Feinstein hits on the very issue you talked about. There were representations made at the January 4th hearing about $80,000 a month was being spent on Mr. Eyman's legal defense in the State versus Eyman case. We didn't have access to those current bank records to know whether the fund that keeps being referred to as the legal defense fund, which is now, well, at the time of filing had been zeroed out, was sufficient to cover all of the retainer money. We can't say for certain that all the retainer money came from that account. And so our concern with this order was that it allowed potentially a restriction of the look at that information to one singular account where other accounts might have been used to fund some of this money or were used to supplement other payments to counsel before that money was run down. And so our concern with the order was to the extent that it said that any funds that were paid by third parties for legal defense, as if that term meant the legal defense fund, would then go into the pool of funds paid. And then all it says here is to the various attorneys herein without sort of description about who those people are, if that meant other people or just the applicants, that kind of thing. So we had concerns about the issues you raised about whose money was actually being spent and over what period of time it came in and when. So we had suggested a broader look back and a broader accounting outside just the legal defense fund, given the representations that were made about the amount of spending that was coming on legal defense.
Right, I get that. Let me revise what I said. I guess this is a hearing to the extent the same issue about showing where the funds came from applies to Mr. Ard's application as well, because that is in front of me today. So it isn't, this isn't all premature, even though I don't have a notice of presentation on for hearing. I will just make the following comments on it is, I am not trying to do anything special in this special or unique or make up some new rules just for this application. In this case, I am trying to maybe fit the square peg into the normal round hole here as far as what gets revealed to the court, or at least to the UST, regarding where funds come from that are paying counsel that are seeking to be employed by the court. So my earlier comments stand. I would expect what goes to the UST is a list of every single donor back until there was zero balance in that account. I'm not requiring any of that to be put on the record at this point. It's a disclosure issue. It doesn't necessarily therefore mean that it's going to have to be on the bankruptcy docket. It just has to be available to parties in interest, and I'm using the UST for that. I'm cognizant of Mr. Smith's worries about that, but I'm not going to hold up administration of the entire case simply because there's a lack of staffing at the UST's office at the moment. So I'm not issuing any sort of stay or injunction of anything in the case based on lack of staffing of the UST. I certainly will be sympathetic to the UST's problem at the moment. The court is about to face that same problem itself, and we're just going to have to deal with that as it goes along. But presumably things that are going to slow down administration of the case, I'm not going to have much sympathy for or be issuing much of anything in the nature of a stay. But issues that can be put off without slowing down the administration, I will be more sympathetic to requests from stay. So I'm not ordering anything right now. I'm just telling you that's my general thinking on this lack of federal budget, lack of any staffing for U.S. agencies other than deemed essential employees at the moment. And I have to hear the rest of the ARD argument before I can rule on the ARD application, but where I'm coming from on the discrete issue of disclosure of the donors is what I just articulated. Now, as to Ms. Dalton's concern that maybe there's other sources of funds here, of course, to the extent the funds are from Mr. Eyman's earnings, I don't care. I mean, we don't. That is what you would expect to have funded the retainers. So if some part of that funding was directly from Mr. Eyman rather than through this fund, I don't need any special disclosure regarding that. And to the extent he hasn't disclosed some other source for these funds, that would be his problem if it's ever discovered that that was the case. I mean, an order approving employment does not foreclose further argument based on new evidence that, in fact, that applicant wasn't disinterested, and that can come up at fee application time or by some further motion later in the case. All right, Mr. Ard. Mr. Smith?
Your Honor, I just wanted to ask whether you would consider disclosure of this information in the order to be both to the state of Washington and the United States trustee, given the position of the state of Washington in this particular case as the gorilla in the proverbial room. And again, you recognized it, but not knowing whether this shutdown is going to go until I retire, whenever that might be, or some other time. I don't want our office to somehow become inadvertently a black hole where the information is provided but it's not disseminated. If you're trying to...
All right, well, let me ask Ms. Dalton a somewhat maybe obvious of the answer question is, do you want this information, Ms. Dalton?
Well, given the fact, Your Honor, that the question of disinterest is a question that the court considers, without it, we can't really make that judgment. So
all right, well, I would say the same thing. It's the state that's bothered to respond to these employment applications, and by my earlier comments, you saw I wasn't restricting access to that list. I was, in fact, contemplating that the UST would give that list to whatever party in interest asked for it. So I will revise my ruling on that disclosure to say that it also needs to be provided to the state via its counsel.
Your Honor, may I please talk to you?
Why don't I let you confer with your counsel and then...
I'm effectively without counsel. I have been since last
So you
January.
No, you have Mr. Feinstein. I don't want this to devolve into a situation where, for some issues, I hear directly from a debtor in possession who's not pro se, and then I hear from its counsel. So I'm going to take a fight.
I'm going to take effectively pro se, sir.
Doesn't Mr. Feinstein represent you?
He does in the bankruptcy.
And this court is the bankruptcy court. So I'm going to take a 5-minute recess, let you confer with Mr. Feinstein, but no, as I would do in any other case when a party is represented, I hear from their counsel. I don't hear directly from them. All right, thank you. We'll be back in 5 minutes.
All right.
Please be seated. So am I going to hear from Mr. Feinstein first or from you, Mr. Art?
I was told in the room that he is effectively not my counsel right now. He hasn't been named yet. So I am without counsel, and I believe that it is appropriate that when someone is not represented, that they have an opportunity to be able to address the court. You have not granted him, because they won't sign the order, for him to be able to be retained. It seems inappropriate that a person that is not represented cannot talk to the court.
Sorry, you have counsel. He's
don't have counsel.
He's appeared for you. Just the fact that an order hasn't been entered yet doesn't mean that the many, many things he's done since filing the case for you were void or ineffective. He is your counsel.
Thank you, Your Honor.
Obviously, I'm here to address my application, Your Honor, and it's, I think, probably a very unusual situation. So, with the court's indulgence, a few things to say about it. And the first one is why it is vitally important that the court approve this application. First, the work I did absolutely benefited the estate, but more importantly, going forward, the estate and Mr. Eyman cannot secure replacement counsel if I'm not appointed and paid. So the state came in to this court.
Why is that?
I'll explain that, Your Honor. The state came into this court and opposed my appointment on the grounds that I had not demonstrated my competence. For a variety of reasons, ensuing after that decision, I filed a notice of withdrawal in Thurston County Superior Court. The state has opposed my withdrawal motion and asked Thurston County to compel me to remain counsel of record in the case through the close of discovery. The discovery that they came to this court and said a solo practice is not competent to handle. So they've told you that I should not be paid and was not demonstrably competent to handle discovery in this matter, and they've told Judge Dixon in Thurston County Superior Court that I should be compelled to remain in this case and work on Mr. Eyman's behalf until the close of that discovery. This is a blatant ethical conundrum for any lawyer. It's among the reasons that I'm compelled to withdraw from Thurston County. But for the estate, it means the estate cannot hire counsel. Attorneys will not take a call from Mr. Eyman for replacement counsel, knowing that they are compelled to enter an appearance in Thurston County into a blizzard of discovery, and I'll give you some idea of what has gone on in the last 10 days in that case, that the state will oppose their attempt to withdraw, will oppose their attempt to be appointed, will oppose their attempt to be paid in this court. They will not take a call. They will not take any steps to consider representing Mr. Eyman. And that's among things that I've been doing in the last 10 days in attempting to help him secure replacement counsel. They won't touch it with a 10-foot pole because of what the state has done. I'm going to be in Thurston County Superior Court tomorrow arguing in favor of my withdrawal in a case where I no longer represent Mr. Eyman because the state opposed my notice of intent to withdraw and asked that court to compel me to perform discovery duties that they told this court I was not demonstrably competent to handle. No attorney will step into that mess. No attorney will step into that mess. So all the prospective counsel have backed out of it.
I still didn't get from what you just said, why are you withdrawing, though?
I think that's privilege, Your Honor.
All right, that's a fair answer.
So, pardon me, to the merits of my application, I gave you a second declaration. You asked for a demonstration that I'm competent to handle complex civil litigation. I listed 5 prominent cases. I could certainly give you more if you'd like more, but I think what you see there is your colleagues in this court know of my competence in complex civil litigation, as do your colleagues in the Western District of New York, in the Southern District of New York, in the District of Columbia, in the Central and Northern and Southern Districts of California. There's an objection, an irrelevant objection, to that second application regarding my pre-petition work. Pre-petition work is not relevant to whether I'm competent to be appointed by the bankruptcy court in this case. There's an objection to what I did. That's also irrelevant to appointment. That might go to a fee application and whether the U.S. trustee approves it, but it's not relevant to the question of whether I'm demonstrably competent to handle complex civil litigation, and I've shown you that I am. There's an objection to paying me to get up to speed in the case with a claim that they're concerned about the assets of the estate. That one is fundamental, Your Honor. New counsel have seen that. New counsel know that the state will oppose them getting paid for the professional obligation, ethical obligation of learning what's going on in this complex case. New counsel have to get up to speed to be able to perform competent professional work in a case, and the state says counsel should not be paid for that. So new counsel, prospective new counsel, looking at this mess, don't want to touch it, knowing that it will take them significant hours to learn what's going on in the case, and they will face an objection from the state that they should not be paid for that vital, professionally necessary work. In any event, it's irrelevant to the question of whether I'm competent and should be appointed, but I point that out to you, Your Honor. That's the kind of actions by the state that are leaving Mr. Eyman absolutely unable to secure counsel to represent him in Thurston County Superior Court.
All right, let me ask you a question there. I don't know that it'll make much difference to me, but I want to get the big picture. What's on for hearing tomorrow in Thurston County?
I filed a notice of intent to withdraw on January 7th. By operation of law, they take effect 10 days later unless an objection is filed. I asked the state, please do me the professional courtesy of not objecting to my notice of intent to withdraw. They filed that objection. It is now set for hearing. I have to go to Thurston County Superior Court tomorrow.
Okay, so that's all that's on tomorrow.
There's a wide variety of things on in Thurston County tomorrow. In the last 10 days, after they asked this court to consider that I was not yet demonstrably competent to handle discovery, I filed a notice of intent to withdraw and asked them to please delay discovery actions in a case where the trial date is a year and 10 days away. Please take a delay while Mr. Eyman can secure replacement counsel. Got no response to that request. I asked them to name the amount of fine and specific injunction terms that Mr. Eyman should agree to settle the case in Thurston County. I got no response to that. I got 15 deposition subpoenas. I got about a dozen third-party document subpoenas. I got 2 discovery motions and a motion to amend a pleading. All after I had noted my intent to withdraw and asked for the professional courtesy of a short delay while Mr. Eyman could secure new counsel. Coupled with an objection to the intent to withdraw, an argument to Thurston County that I should be compelled to engage in discovery, and, as Your Honor is aware, objections to my appointment and compensation here. So it's that mess that has left Mr. Eyman in a position where attorneys, considering whether or not to represent him, won't do it unless they see that I am appointed non-pro-tunc and paid, because they're petrified of getting stuck to this tar baby in the position that I've been put in of 7 weeks of work for the benefit of the estate, all work that the state has demanded of me, even in the face of a request for a delay, and simultaneously said he shouldn't be paid for doing it. And so no one else will touch this case. The estate will be left represented by Mr. Eyman pro se in Thurston County Superior Court if he can't get counsel, and he won't get counsel because everyone looking at it has seen what's happened to me. So I would say I've absolutely done work that's benefited the estate since the filing date. I'm absolutely competent to do the work I did. I absolutely meet every rule to be appointed non-pro-tunc and should be paid for it. And if I'm not, the estate is going to be left pro se, represented pro se by Mr. Eyman in what the state has described as an extraordinarily complex case where he desperately needs counsel and can't get it.
All right, thank you. Ms. Dalton.
For the record, Linda Dalton representing the state of Washington, one of the two creditors in the case. As you probably can anticipate, you're going to hear a much different sequence of events from me than you heard from Mr. Ard. With respect to this application, as the court knows, litigation comes with rules. There's statutes, there's regulations, there's the bankruptcy court's rules on how issues are processed. There's civil rules apply in the state court about how, and that no one is exempt from following those rules, and that includes the debtor in this case. So what you have before you is a situation in which an application was made on December 14th asking that Mr. Ard be appointed counsel, special counsel, under the bankruptcy court rules. He had already appeared, substituted in for prior counsel or the other creditor in this situation. He did that on November 30th. At that time, there was approach to the trial court asking for a temporary stay of that matter till the state's position on a comfort order could be addressed by this court. At the time, Mr. Ard appeared on behalf of Mr. Eyman and the other defendant he represents, Watchdog, Mr. Eyman's Watchdog, LLC. He appeared at that hearing. At that time, the trial court agreed to temporarily stay the matter. And that particular order, which Mr. Ard signed, had a number of trigger dates in it when this court issued its order on the state's motion. Those included a reinstitute of the discovery cutoff, which was to occur 35 days from your order. Written discovery that had been pending since November would be required to be filed within 16 days of your order. Any motion that the state wanted to do to revise the special discovery master's order would need to be filed within 5 days of your order. So there were triggers from the state court stay that applied to this case. And I'd like to say at the outset, when the bankruptcy was filed, the depositions that have been renoted now were pending. All the subpoena ducas tecums that were out there to be returned on were pending. Discovery cutoff was scheduled for December 14th, about 2.5 weeks later. All of these matters were pending. And the state, in its response to you, pointed out these issues, never hid the fact that discovery was going to continue once this court acted. All of that information was available to Mr. Ard and to his clients at the time the bankruptcy was filed, at the time the trial court entered the temporary stay. So none of this was a mystery or should have been any surprise. In addition, there were motions that were pending at the time the bankruptcy filed. Those also got set over, and those have now been renoted. All of this was pending at the time the bankruptcy was filed and due to be completed by December 14th. So to the extent that there is a picture being painted for you that somehow this is a deluge that was unforeseen, all of that is wrong. It was all existed at the time the bankruptcy was filed. So what you have now is a situation where your hearing, you raised questions. And contrary to the representations that have been made both to this court and externally, Mr. Ard's competence wasn't challenged. The question came up about his capacity. In fact, during the hearing on the first motion, the state acknowledged that he was a very experienced litigator. So, and this court determined that you weren't going to expect him to have campaign finance experience, but that you determined that his application was deficient because it didn't provide you the information that you need in order to review it to determine whether it's in the best interest of the bankruptcy estate. So the court asked for additional information, curriculum vitae, you wanted scope of work, was one of the other places where you had asked for information. You didn't reject the application, though you could have. that was an option that was available to you. What you did is you provided counsel and the debtor additional time to provide you the information that you determined you needed. So to the extent that the state is being painted as to use Mr. Smith's word, the gorilla, in this situation, it isn't. The obligations belong to the debtor. The debtor's obligation is to provide you the information you need to make your decision. And you determined that it wasn't sufficient at that time. So the matter was continued. So then what happens, the next business day, the notice for intent to withdraw from the state case comes in. And contrary to representations that have been made at the state court and that are being made to you now, the state did what the civil rule allows. The civil rule has a series of steps that an attorney must take, Rule 71, before they can withdraw from a case. They have to provide information, which Mr. R did not provide, including the location of the clients and where they can be served by the opposing party. But also recognizing that discovery at the point that he was doing that was 5 weeks away and had been set over based on the filing of this bankruptcy. So the state objected, filed its objection. The state has done merely that. The rule then requires relief from the court, the trial court, before withdrawal become effective. So to the extent that Mr. Art stands here and tells you he's not representing Mr. Eyman, that's not the effect of the rule. He cannot withdraw from the case. He remains counsel of record until such time as the court orders. There is the motions that the state previously had pending when the bankruptcy was filed are pending for tomorrow. A motion to amend the complaint, a motion to revise the special master's order. There was an order from a previous motion that had never been entered, presentation of that motion. So those are pending in the state versus Eyman case. Nothing has been noted. There's been no motion filed to note up Mr. Art's request to withdraw from the case. That isn't on the calendar for tomorrow. I am reading into his comments that he's going to try to get that heard tomorrow, but there's no motion pending and it's not set. So going back to what this process is all supposed to be about today was to determine whether it is appropriate or in the best interest of the estate to appoint Mr. Art. And essentially what I think the takeaway from the application at this point is he acknowledges in his declaration to you that he is counsel and wants to be paid through the time, and I will read it to you because I think it's important. From the date of the filing of the debtor's petition through today, which was the effective date put on his notice of withdrawal, or such later date as the governing laws, applicable court rules, and the court in that case, the state versus Eyman case, allow me to withdraw as counsel. So what he's looking for is a limited appointment to cover essentially to get paid for the period of whatever he's done. And the issues of if you appoint him, the legitimacy of those billings would all be addressed at a different situation. You're only dealing with the question of appointment at this stage. So it's kind of got a bit of a vague end time. But what's clear from the presentation that you've been made is that Mr. Ard does not intend to stay and work on this case. He has told the court below, he's telling in a response he filed to the objection, he's told the state counsel that he does not represent, despite the statement in here that says that he has to wait for the court below to give him an order allowing him to withdraw as counsel. So, in fact, if you take him at his word that he's just here to get paid for whatever he's done, then how is he not just then a creditor, like any other creditor? He believes he has money owed to him for the work, and that's why he's seeking the appointment, is to get that. All the other information that you heard is not part of any declaration about attempts to gain counsel for Mr. Eyman. All of this information, it's not part of the record. It's, the state can't refute it because it, it doesn't have anything to refute. So the question remains to you then, has the debtor met the burden of establishing that appointment of Mr. Ard in these circumstances is in the best interest of the estate? There's no CV that's been provided to you. He provided a list of about, they were bulleted 5 different subsections. And if the court deems that that's appropriate and you don't have any issue about the word that the state used about capacity, that may not be necessary for you to review if he's not intending to actually work while he's still counsel of record on the case. Might not be an issue. But there are things that need to be done below. They weren't a mystery at the time the bankruptcy was filed. They weren't a mystery at the time Mr. Ard came into the case, but now he wants out with no explanation. So at this point, we're going to leave it to the court to determine whether you have received enough information to appoint Mr. Ard as counsel. And based on the representations he's made, it would only be for a time certain. And apparently just so they can find other counsel. Do you have any questions, Your Honor?
I don't. Thank you.
Thank you.
All right. So at the January
Your Honor,
4th...
if I might address a couple of those statements that suggest I have been misleading this court or the court below.
I don't need to. It's
Very
not
good.
relevant to what I'm going to rule.
Okay. Can I make one?
You may, Mr. Feinstein.
Mr. Eyman jumped up to speak to this debate is not at the comments that the court made because he understands the disclosure requirements that the court was discussing. It was apparently some comment made by Mr. Smith that if we provide the donor information that he suggested that could or would be provided to creditors upon their request, and that's when he kind of jumped up. There's this, apparently wanted to explain to the court, there's a specific distinction in disclosure laws under Washington State for political action committees, that there are detailed disclosures that have to be made on a regular basis, monthly or whatever it is, on all donations made to political action committees. But it specifically exempts disclosures to legal defense funds. And those funds are solicited separately, and they're solicited under confidentiality requests. That your name will not be given out, the amount you give me will not be given out, it will not be disclosed, it will not be told to any person. So donors sometimes, and not sometimes, but they will give 2 checks, a public disclosure check for the political action committee, and then a separate check for the legal defense fund, which is not disclosable. So when the court understands that he will provide that information to the U.S. trustee because of the request, that the U.S. trustee suggested it may be then made available to a creditor or any third party, that violates then the solicitation of the funds under the confidentiality agreement. He wanted to make sure that there was some, not clarity, but some definitive ruling that won't be violated. And that's when he kind of jumped up and he says, those funds are solicited under confidentiality, and if I have to give them to the U.S. trustee under some kind of order of confidentiality, I understand that. But to the extent that it was suggested that then once the U.S. trustee has it, it can be made available to third parties, that's when it kind of thing. So he understands under the political action committee disclosures, those are monthly, they're public, you have to disclose them. I think there's a threshold of $20 or something. So if somebody gives you $10, you don't have to disclose it. If they give you $21, you do. And those are done every month. And that's done to the state through the political action committees that he's works for and works with and things. But the legal defense funds are a different animal. And we've kept track of those. We have all the checks. We've provided the checks backwards for a period of time, and the bank statements for, it says, and the checks say right on them, and Mr. Smith has them. It says, Tim Eyman Legal Defense Fund, right on the check, and that's who the pay or is, because it's different than paying Mr. Eyman or the PAC.
All right, well,
so he needs a clarification.
Let me raise a procedural point with you. I fully appreciate everything you just said. It was the kind of information I kind of expected to hear at the last hearing. And I am concerned about it. And I want to understand if there's a clash between a privacy-related non-disclosure law of the state and the normal requirements for revealing the source of funds for counsel to show disinterestedness. I'll have to resolve that clash if there really is one, or I'll have to determine there really isn't a clash here. Yeah. But I think that puts back in play even the 2 applications that I've already approved, plus the one for Mr. Ard, at least on that aspect. So I'm going to have to set it over for a hearing and further briefing. I fully want to hear from Mr. Eyman on what, meaning you in this case, on what those privacy restrictions are under state law and whether we have a clash of the federal requirements for employment and the privacy of legal defense fund donors. And then I'll have to resolve that. But I don't even have that statute in front of me right now. So at the end of this, let me continue with the ARD application first, but I think then we're going to have a further hearing that addresses that issue before I can even enter an order at all on the 2 previously orally approved applications. I think that nuance needs to get dealt with appropriately. All right, so on the ARD matter, I do find, although I might have used the word CV at the last hearing, I needed to see in writing a supplemental a submission on the qualifications of Mr. Ard to handle the matter. I found those to be sufficient. I find it to be in the best interest of the estate in satisfaction of the requirements of 327, other than following up on this issue of disclosure of the sources of the funds for the retainer for Mr. Ard, that he be employed. So other than resolution of this issue on disclosure, I will grant the application of Mr. Ard to be employed as counsel for the debtor in possession in relation to the Thurston County litigation. Make sure I've not missed anything I'm going to cover at this juncture. I think I addressed the legal standard last time, so I'm really just following up. This supplements my previous findings and conclusions on that. However, the new aspect that's raised in Mr. Ard's revised or supplemental filing, asking also to withdraw at the same time that I appoint him, I'm not going to rule on that at this point because it's procedurally defective. Just as Ms. Dalton pointed out that Rule 70 or whatever it is in the state civil rules has certain requirements on it, our own local rule 2089-1 has very specific requirements in it for any counsel wishing to withdraw. So although I'm not in a position to enter the order yet appointing Mr. Ard, I have no doubt that eventually, once we resolve these privacy issues, that I will be issuing an order appointing Mr. Ard, but I can't at this point let him withdraw without compliance with 2089-1, which requires, unless there is replacement counsel, it's a very simplified process. If you have replacement counsel, I understand the chicken and egg problem you've tried to describe here as far as Mr. Eyman being able to find replacement counsel in the Thurston County matter, but I still need compliance with our local rule on withdrawal where there's not a substitution. We need the application. I need the motion noted for hearing. The contents of that motion are set forth in subsection C of that rule I just mentioned. and it must contain the client's mailing address, telephone number, and email address, or a certification of attorney that he's made reasonable efforts to find that and can't. But here, that's not going to be an issue. It's right on the docket, how to contact Mr. Eyman, and he also has bankruptcy counsel, so that's not an issue. Although it still needs to be complied with in the application. A statement that no deadlines, hearings, or trials will automatically be continued as a result of the attorney's withdrawal. Well, I guess you'll know more on that tomorrow. And if the client is not an individual, a certification by the attorney that the attorney has notified the client that the client may not appear or file pleadings pro se, and then it has a service requirement. I think under our circumstance, I don't think I've ever had a situation where there was a potential clash between whether counsel would be allowed to withdraw in a state court matter that he's been presumably will be approved to represent the debtor in, and then our local rules or any other bankruptcy rule for withdrawal of that counsel. I also don't want to put Mr. Ard in the position of not being able to get paid for his work if I allow the withdrawal here and then it's not allowed in Superior Court. So at this juncture, I'm not going to rule on any request to withdraw. I will continue the application for employment, but again, that doesn't have the effect, Mr. Eyman, of saying he's not authorized, he isn't representing you at the moment in the Thurston County matter, or that the delay in the nunc-pro-tunc application of Mr. Feinstein delays Mr. Feinstein. He does represent you in this matter at the moment. So we need to talk about some dates.
I can't address the inaccuracy of what you just said, that I am with counsel that can't actually do work on it because of his ethical obligations to not help somebody who is... Never mind. Thank you, sir.
I will make this comment, too. It's unlikely, even if you follow the rules for your withdrawal, it's unlikely that I would allow the withdrawal if Thurston County isn't allowing the withdrawal. I just say that. I haven't thought that completely through, but my gut reaction is where you have two court masters, if you will, the employment process in the bankruptcy court for special counsel, and then the pending non-bankruptcy matter that you're representing them in. I can't envision that I would authorize withdrawal before Thurston County has, unless Thurston County says something like, well, we'll let him withdraw if Judge Barreca lets him withdraw. I mean, it is somewhat of a chicken and the egg problem. Like I said, I've never faced it. Nobody cited me a case law on how it should work out, but I don't want to put you in the position where you can't apply to get paid, and yet the Thurston County Court is requiring you to continue to represent Mr. Eyman in that matter. So my concern isn't simply to protect you on your fees, but that would be a concern. All right, let's talk about dates for this privacy issue that's now been raised. And I think just to tidy things up, those should be considered a reset of hearing on the two applications that I orally approved, in that it's, the applicant himself that's raising the new issue that needs to get dealt with, I think, with some care. And we can do that by minute entry. So you don't need to file a new notice on the old applications. We will, just by minute entry, come up with some language that makes it clear we're going to have a further hearing on all of the applications for which an order hasn't been entered yet, other than the one that's been withdrawn. So it's your client's concern, Mr. Feinstein. How long do you think you need to brief it?
It won't take that long. You have sometime in 2 weeks or Just
Well, I have a
something-
regular
we
set of
would wanna
hearings
put
on the
just-
31st. I
Okay.
guess my inclination would be to aim for the 31st.
We're just looking at being able to prepare a declaration with the confidential solicitation information for the court to review and then appear, so.
So if you could get that in by the 24th, and I would set the state's response at the 29th at noon.
So, January 31st?
January 31st for hearing at 9:30. 24th, you need to honor before the 24th of January for your further submissions on the issue.
Okay, that's a week, okay.
And then the 29th. Let me think this through for a minute. Yeah, I think that still works. 24th for your submissions, Mr. Feinstein. 29th at noon for the state's responsive pleadings, if any. I'm not requiring them to file a pleading, but if they want to file a pleading, they need to do so by the 29th at noon. And limited to the issue of disclosure of the legal defense fund donors.
And can we get at least an understanding today that since that is the issue, that the records that we provided to the U.S. trustee, which we thought were under some kind of non-disclosure, will stay non-disclosed until at least the court rules on whether...
I haven't entered any written order that I'm aware of on this issue at all. You just have my oral findings and conclusions that, having not heard about this important nuance raised by Mr. Eyman, there's no ruling of the court at all that's enforceable at the moment about disclosure of that list. And we'll settle that on the 31st. All right. Any problem with that schedule, Ms. Dalton?
No. One point of clarification, though, and we just want to make sure it's clear for the record, since apparently we'll be addressing this to Judge Dixon tomorrow, is that you have approved Mr. Ard's appointment in the State versus Eyman case.
Subject to
The proviso.
disclosure of the donor list in a manner that I will determine on the 31st of January.
Correct. So the issue that hasn't been addressed is the State versus tougher to raise taxes and Mr. Eyman's role as a defendant in that case. At the time you had the January 4th, they had wrapped them all together, and that we haven't set his appointment include that case also.
The original application was intended to that, even though you missed it, and wasn't it addressed at the last hearing that you were requesting to represent Mr. Eyman in both matters?
I was at that time. I do not intend to represent Mr. Eyman in tougher to raise taxes. I have not entered an appearance. I do not intend to enter an appearance. I don't have any attorney-client relationship with Mr. Eyman with respect to tougher to raise taxes.
If I may, Your Honor?
It's interesting, but... Yeah, go ahead.
There's a motion for default set tomorrow in that case for all the defendants. And Mr. Lamb has done a similar notice to intent to withdraw that the state objected to until such time requesting that an answer be filed on behalf of all the defendants, including Mr. Eyman.
I guess I will address that issue. I hate to leave you the unclarity for the Superior Court, but I had an oral clarification of the original application back at the last hearing. Now I have an oral further amendment requesting that the scope of that application be limited to the Thurston County matter that was specifically referenced in the written application. I will rule on whether I would allow that further amendment. I don't think I'm going to force, just because he said it at oral argument, I doubt that I'm going to force him to represent Mr. Eyman in that, but I haven't heard from Mr. Eyman either. I mean, I guess what I don't know at this point, I don't have any pleading in front of me that has Mr. Eyman objecting to the withdrawal. So I don't know where that leaves us either. So I haven't ruled on the withdrawal. I won't be ruling on the withdrawal. I don't have any motion pending on the withdrawal yet. I'm going to require compliance with the local rule regarding any request to withdraw, but since I haven't even entered the order on the original employment application, the breadth of that I will also determine on the 31st.
This matter is also before Judge Dixon, so we got one judge for that. We'll address it with him then tomorrow. Thank you.
All right. Thank you.
May I just ask, am I represented in tougher to raise taxes or not?
I have no idea. I mean, I do not know, because that's really a matter for the Superior Court at the moment.
Very good. Thank you, sir.
Your Honor, Martin Smith, United States Trustee. I just wanted to clarify for the parties' benefits, given Your Honor's comments about there's no order restricting dissemination of the information that's already been provided with respect to donors, the United States Trustee will not be providing that information prior to the January 31st hearing to any party. We typically would not otherwise, absent a subpoena for things like copies of checks and things that have been provided to my office. And so just so that...
And then that makes good sense to
everybody
me,
knows
given the
it will
assertion that there's restrictions under state law.
It will not be leaving the office.
All right. Thank you, Mr. Smith. All right. On to the next matter. Thank you. Which is Ronald Wynn, DDS.